Well, thank you so much. I think this is the most kind and generous introduction I ever had in my life. Hello everyone. First of all, I just want to say a big thank you to Professor Priora and to the entire team of Nova IPSI for inviting me to speak here today. It is certainly a great honor, but also a pleasure to be here and to engage with such an important and fascinating topic. I would also like to congratulate Professor Priora and her colleagues on really outstanding work your center is doing in giving us this vision or notion of intellectual property as not simply some mechanism for the regulation of exclusive rights, but as this infrastructure which is deeply intertwined with broad societal transitions, including sustainable development, environmental protection, also access to culture and technological fairness, among others. So I was asked today to speak about the rising focus of IP and sustainability in legal doctrine and beyond. And in approaching this topic, I thought that it might be useful to begin with the notion of sustainability itself. So the concept of sustainability or sustainable development originates from the report of the United Nations World Commission on Environment and Development from 1987, where it was defined as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And as you can probably see from this definition, the concept of sustainability is by no means limited to environmental concerns alone. So in IP and sustainability debate, for instance, the discussions touch upon now, they go far beyond climate or ecological issues to encompass also questions of public health, inclusivity, equality, access to culture or access to knowledge, among others. From this perspective, intellectual property has been approached, for instance, through the lens of the ability of the system to prevent and respond to health emergencies, of course, particularly in the context of the COVID-19 pandemic, but also through the lenses of social justice and inclusive innovation. And we can think also here, for instance, of the many debates we saw on the need for patent waivers or vaccine equity during the pandemics, but also of the disability exceptions and accessibility issues in copyright law. Also now there is a growing research into protection of intangible cultural heritage, gender equality, cultural participation, and access to knowledge. So this notion of sustainability in IP is not reduced to environmental protection, and it also focuses on these broader efforts to ensure that innovation systems contribute to the socially inclusive, equitable, and resilient societies. And yet, this environmental sustainability is probably one of the central focuses in the current IP and sustainability debates. For this reason, as well as this is simply closer to my own field of research, I thought that I will limit my remarks today to environmental sustainability and IP specifically, while then fully acknowledging that relationship between IP and sustainability extends much further. So having made this disclaimer, let me suggest that the rising focus in IP and sustainability in legal doctrine and also in practice is a result of two intertwined but parallel developments. So on the one hand, we are all living now through a rapidly aggravating environmental crisis. Here in Portugal, you guys have just broken the record for the hottest day in May. I guess it's no big news to anyone that overproduction in particular contributes to this negative dynamics. Fashion production, more specifically, makes up to 10% of humanity's carbon emissions, contributing to global warming. So as a result, there is this growing, even pressing recognition of the need to be more environmentally conscious, with many areas of law now starting to test their long-standing assumptions and approaches against these pressing realities of climate change. And intellectual property protection is, of course, also not an exception here. Then partly as a result of this first dynamic, we are also witnessing a rapid growth of sustainability-oriented practices of consumption, such as repair, refurbishment, recycling, and in particular, fashion upcycling. So I guess everyone understands what it means. So recycling is practically or repair is practically fixing, refurbishment is restoration, and upcycling is a creative transformation of old items or their parts and integrating them in new, sometimes totally different products. So one good example of upcycling, for instance, is when you take your old denim jacket and then transform it into a stylish tote bag. Or another example is when a young designer takes old Louis Vuitton bag and integrates parts of it into a street-style bomber jacket. So I guess I don't need to explain why repair, refurbishment, and upcycling are beneficial for the environment. So they have this good potential to reduce waste, conserve resources, and minimize the demand for new production, so thereby also lowering overall environmental impact. And consumers are now increasingly interested in purchasing repaired or upcycled products. And as a result, the markets also specializing in repair or upcycling are rapidly growing in popularity across the globe. So to give you just a few examples of these markets, this North Carolina-based artist, for instance, upcycles old silk scarves and luxury packaging into this type of three-dimensional handmade works. And his items incorporate upcycled old packaging not only from Chanel, but also from many other luxury brands such as Louis Vuitton, Tiffany, Fendi, Hermes, Gucci, and many more. And here is yet another example already from Europe. So this young French designer, Clémence Chicoury, gained popularity from upcycling old Louis Vuitton bags and suitcases into this type of bomber jackets. And these are not just some rare examples. This website, for instance, gives you advice on 10 things which you can make using your old IKEA shopping bag, which include items such as this, for instance, this, or even this. And also this designer specializes in footwear and bags made from scraps of sportswear produced by, among others, Nike, North Face, and Patagonia. Also, this designer produces dresses made from old T-shirts. And as you can hopefully see on the slides, and some parts of his dresses quite distinctly incorporate the original T-shirt with producers' logos such as Puma and Fila. Then we also have upcycling practices booming in popularity not only in the area of clothes production, but also in the field of accessories. So this website, for instance, sells old authentic Chanel buttons turned into necklaces. And this one markets tote bags made from old Nike shoe boxes, and it emphasizes separately on the website that those would have otherwise ended in the garbage dump. Now, upcycled products actually can be used not only for clothes or accessories creation, but even in furniture production. So this young South Korean artist or designer specializes in the creation of furniture and other interior design items, such as lamps made out of, again, old Nike shoe boxes or even old McDonald's meal packs. And these upcycling practices are so widespread to the point that I guarantee you that once you start paying attention, you won't be able to unsee them anymore. So I myself, for instance, this winter just bumped into a moving art exhibition near my home in Haarlem, where some items which were also offered for sale included the clutch, which you can see for you on the left side of the screen, which was made out of old Hermes fabric and also was featuring, as you can see very proudly, Hermes inscription over it. And just last month, when I was on vacation, I came across a local market where one stand was devoted entirely to bags and clutches made from upcycled product packaging, which included also the clutch you can see in the middle of this slide, made from viscose cat food packaging, or also the shoulder bag made from Lavazza coffee bags. So, despite the fact that these practices are beneficial for the environment, and also as these sustainability-oriented practices become more economically available, then the economic interests surrounding them also intensify, and as this interest intensifies, so too does litigation, including on the basis of violation by these businesses and practices of intellectual property rights. So, for instance, in Germany, a business which was involved in replacement of firmware on old Wi-Fi router boxes, on which then the box's producer's trademark was still visible, was sued for trademark infringement. Then in the US, Chanel sued also for trademark infringement the company which was marketing and selling authentic Chanel buttons turned into necklaces. In Canada, also the business which was specializing in the creation of customized electric bicycles, integrating genuine parts from Harley-Davidson motorcycles, was also sued and found infringing Harley-Davidson trademark. In Finland, probably everyone heard of this case, a local fashion designer was sued successfully for copyright infringement by the company which produced and marketed the tableware which these designers then used for the creation of her unique jewelry pieces. And they sued this designer for copyright infringement simply on the basis that they owned copyright in the ornaments placed on these original plates and other tableware. Now, more recently, also in France, the integration of old second-hand Hermes silk scarves into denim jackets was found to violate both copyright and trademarks of Hermes. And finally, in Finland again, a private individual was prohibited from listing for sale on an online resale platform a single copy of a dress she had made just in the best traditions of Scarlett O'Hara from Gone with the Wind, from her decade-old Marimekko curtains. And she was prohibited from selling online this single copy of a dress simply because the ornaments which were placed on these curtains and which were then, of course, naturally visible on the dress as well, were protected by Marimekko's copyright. So what all this litigation demonstrates is that these are not just some marginal disputes about individual products or businesses, but they rather reveal a deeper friction between, on the one hand, this traditional logic underlying intellectual property law protection and the emerging logic of sustainability-oriented economic practices. And the contemporary scholarship on intellectual property has responded quite vigorously to these frictions with the increasing number of academics emphasizing that the way intellectual property laws are currently designed and interpreted across trademarks and copyright, but also in the field of patent law, design protection, or remedies for IP infringement, often hinder and not support sustainable reuse practices. And the focus has been, in this respect, first and foremost, naturally, on the doctrine of exhaustion of intellectual property rights, which practically means that the IP holder loses any further control over the physical copy of the good or product which that right holder had already placed on the market with their consent. So on the first side, this doctrine of IP exhaustion appears as a perfect avenue for accommodating the interests of these sustainability-friendly businesses because they all essentially, all repair businesses, upcycling, refurbishment, they all deal with the old physical copy of a good which was already once placed on the market with the IP holder's consent and for which that IP holder has already once received remuneration. The existing scholarship, however, demonstrates that this doctrine currently applies to the products only in their original condition, and so it doesn't capture any modifications to existing goods or their integration in other products. And the result is that most of our sustainable reuse practices then cannot be shielded on the basis of the trademark exhaustion or copyright exhaustion doctrine. Then a number of scholars, particularly in the field of EU trademark law, also point out at the expansive interpretation of the trademark law's preliminary infringement criteria of use in the course of trade and use in relation to goods or services. So these infringement criteria capture many of the transformative reuse practices, even if no consumer confusion arises as to the origin of the goods or services at issue. So in particular, the criterion of use in relation to goods or services has been interpreted very broadly by the Court of Justice to require nothing more than a mere link or association with the goods of original trademark holder. So practically, even if we as consumers perfectly understand that, let's say, Audi cars repair services are not provided by Audi itself, or that our empty containers such as gas bottles or cylinders for carbonating machines are refilled by a different company than the one which produced these containers, or then again that our Nike tote bag made from old Nike shoeboxes is not produced by Nike itself, then we are still dealing with the user in relation to goods or services in the sense of EU trademark law, because then the link or association with Audi, the containers producers, or Nike is inevitable, and it is practically even at the very nature of all of these practices and businesses. Now, a number of scholars also look at the area of intellectual property law exceptions in order to try to establish whether probably those could be shielding our sustainable reuse practices. But here, too, it has been demonstrated convincingly that existing exceptions are often either too narrowly interpreted or their scope of application is too vague, or simply they don't well fit to the goal of accommodating sustainable reuse practices. So this has been shown, for instance, in the field of EU trademark law with respect to descriptive and non-distinctive use exception, and in particular with regards to referential use, and also more recently this has also been demonstrated with respect to the due cause defense. And in the field of copyright law, the same story, it has been shown that potentially applicable exceptions of quotation and pastiche are not capable to readily accommodate particularly upcycling practices, even though the recent rather flexible interpretation by the Court of Justice of the pastiche exception, in particular in Pelham 2, probably opens some interesting avenues in this respect. And finally, academics also point to the fact that all these problems which I have just listed are additionally compounded by the fact that one single upcycled product could be covered by a number of intellectual property rights. So it could be covered at the same moment by copyright, trademarks, industrial design protection, and sometimes even patents. And this then IP rights overlaps further complicates sustainable reuse practices. Now, as to the reasons for such restrictive effects of IP laws on environmental sustainability, scholars point to the IP laws' historical development within a linear economic model which is centered upon exclusivity, controlled distribution, so this incentivized consumption, which then conflicts with the circular economy model on which our repair, refurbishment, upcycling, and other transformative reuse initiatives are built, which values sharing, reuse, and prolongation of products' life cycle. Also, a number of scholars point to the expansion in the scope of protection for intellectual property rights in modern legal systems. So, for instance, trademark law protection has expanded from being originally only or mainly the protection against consumer confusion to include now also the protection of distinctive character and repute of well-known trademarks, which is then the kind of protection that now poses most problems for sustainable reuse practices. And in the field of copyright law too, it has expanded to capture now many objects of applied art, including fashion items, and it also has been interpreted to the effect that now any modifications or alterations to the physical products which incorporate copyright-protected works are interpreted as being covered by the exclusive right of reproduction and not by the exclusive right of distribution, which then could be very easily accommodating all the sustainable reuse practices through its doctrine of exhaustion of distribution right, which then naturally doesn't apply to the right of reproduction. And finally, contemporary scholarship also points to the lack of coordination between IP law and other regulatory frameworks, which includes then environmental law, consumer protection, and cultural policy. And this fragmentation is particularly visible in current doctrinal debates where then goals of sustainability and rationales for IP protection can often simply coexist within different conceptual frameworks. Now, of course, everything, the picture which is painted by academics is not necessarily always too dark. So a number of very well-reasoned and elaborated proposals for improvements or solutions is also advanced. So within the field of trademark law, proposals are made in favor of a more permissive interpretation of the principle of trademark exhaustion, which would be capturing still modifications of original copies of trademark goods. In addition, academics also argue in favor of more flexible or rather more narrow interpretation of trademark law's preliminary infringement criteria, particularly of the criterion of use in the course of trade. So it would be of use in relation to goods or services, so it would be understood rather as a use indicating the commercial origin of the products of the infringer, but not simply a use suggesting any link or association with the goods of original trademark holder. And also in the field of trademark law, exceptions proposals are advanced in favor of a more flexible interpretation of, in particular, referential use exception and its requirement of honesty in industrial and commercial matters, so that it would allow to accommodate still transformative reuse practices. And more recently, some proposals were also advanced on how the concept of due course could be interpreted as to still accommodate particularly upcycling practices. Within the field of copyright law, similar stories, so scholars advocate in favor of more permissive interpretation of the principle of copyright law exhaustion, which would then practically mean that physical products incorporating copyright protected works would be understood as covered by the exclusive right of distribution, and then it's a principle of distribution rights exhaustion and not by the exclusive right of reproduction. And within the field of copyright law exceptions, likewise, the proposals were made on how the quotation and pastiche exceptions could be interpreted so as to still accommodate upcycling practices. And as I mentioned already, the recent interpretation by the Court of Justice of the pastiche exception, in particular in Pelham 2, is well aligned with these proposals. Now, on a more fundamental level, a number of proposals were advanced on how to rebalance this overly broad scope of intellectual property protection by balancing it with the emerging human right to a healthy environment. A number of academics also advocate in favor of introducing autonomous, self-standing IP law exceptions specifically designed to accommodate sustainable reuse practices. And also, some argue in favor of soft law mechanisms, so such as sustainability education or transparency measures, including digital product passports. So let me conclude with this. What can be said with absolute certainty when looking at all this wealth and patchwork of different academic proposals and discussions in the field of IP and sustainability is that the relationship between IP and sustainable development is no longer peripheral. It is becoming central to how we understand the function and legitimacy of IP system itself. And this is precisely perhaps why the work of centers such as Nova IPSI is so important today, because you guys show us that intellectual property cannot be any more understood simply in isolation, but it has to be viewed from the perspective and assessed from the perspective of these broader societal developments and transformations, including sustainable development, climate change, and generally broader social responsibility. I hope I'm not over time. So thank you so much.
Thank you, Francisco, for this great presentation. I think it's of course, it's true what you said, but not entirely true. and first and foremost, thank you, Julia, for this flattering invitation. It is an honor and a pleasure. Thank you for the invitation for myself. Thank you also for the possibility to do the keynote speech. Thank you for this possibility to do the keynote speech after Elena. So Elena did a wonderful job. We coordinated together, but now my turn is definitely easier because she presented so well all the issue and principle in the institutional framework of intellectual property and upcycling. That's, and sustainability. So I can focus on something a bit different, and I took seriously the invitation by Julia to try to also prepare something different, and so let's have this kind of talk. Let's try to think about this topic and to look at it maybe with a different perspective and to start a discussion. So that's the idea. I will try in this way. Focus on IP and sustainability is rising, as the title is communicating to us, but where? Why I'm saying where, in the sense that I want, when Julia invited me, I decided to pay this little homage to her comparative law background, talking about formants, in the sense that we can see doctrine, case law, and legislation. Okay, doctrine is talking about IP and sustainability. Yes, it is. We are here. We are a bunch of people talking about IP and sustainability. Elena did a wonderful job. I just wanted to add something that maybe to a certain extent is an answer also to some questions. And for example, exhaustion and trademark rights about upcycling. The idea is that you have to face the legislation as it is, and it is a bit uphill, and so at least myself, I try to figure out an interpretation of this idea of legitimate reasons and modification in order to try to rebalance the situation, but with the law that you have. So, of course, it is uphill, as I was saying. You have to figure out something, but I think that's what the doctrine is doing, is trying to reinterpret IP in light of sustainability. Case law, okay, we're not really in a good position, and Elena explained really wonderful all the situation. Let me just add the necessary reference to the Audi case, of course, again, and so not a really favored interpretation for repair under trademark rights. But of course, again, it depends also a bit on how legislation is made, and that's why I'd like to focus in this talk on legislation. IP and sustainability is rising in legislation. Is it? Let's check. Let's see how is the situation. I try to look at different, let's say, things that are happening in the EU legislative agenda. For example, the eco-design regulation. I think that everybody knows about it. And to a certain extent, sustainability is the core object of the eco-design regulation. So the eco-design requirements that are provided by EU law in order to access the market. So they are technical requirements for the entry in the market of certain products. We have normative definition. The core object of eco-design is sustainability. It's there. You can check the regulation and you will find a lot of references, and even, as I was saying, definition about sustainability, repair, refurbishing, and also the idea of how products should be sustainable from the technical perspective. Intellectual property is there. Let's say it is untouched. There is just one tiny, tiny reference about the digital product passport, but let's say that it's quite ineffective, or at least it's not really something that it is regulated by the eco-design regulation. Then we have the anti-greenwashing directive, another piece of legislation we are well aware of. Sustainability is there, of course, the core object of this legislation. We have normative definition. Even the objective, of course, is directly tackling greenwashing, and so to a certain extent enhancing sustainability. Intellectual property is there? No, I think that it is quite untouched also from this directive. In Italy, we have this strange situation because we translated the directive as sustainability marks. Instead, it is sustainability labels. Now, the law implementing the directive have corrected, and now it talks about, even in Italy, about etiquette labels, not marks. But to be fair, the directive in itself is not touching upon intellectual property. It's talking about labels. It's not talking about trademarks. So then there is, of course, the exercise by the doctrine. Giorgio can confirm it, about trying to match trademarks and sustainability labels or other implications, but it's not something that has done the legislator in itself. Then we have the discussion, the regulation proposal about new genomic techniques. I think even this piece of legislation is something that you are well aware of. Of course, sustainability is quite central because the idea is to promote new technologies related to biotech, let's say. And so there are regulatory incentives for this kind of innovation. There is a monitoring approach towards the sustainability of this kind of technological innovation. But even in this case, let's say intellectual property is not really something there, in the sense that there is just in the agreed text that maybe will be approved by the European Parliament, some obligation in terms of informative transparency. There is a push for the willingness to license, but nothing more than this voluntary approach. So it's not really something tackling intellectual property. I don't want to go into the merits of the patent ban proposed by the European Parliament in the first stage, but then just to have this, let's say, systemic methodological approach. They are not really, even in this case, I think, talk about NGTs integrating sustainability and intellectual property. And to a certain extent, as a confirmation of this situation, we have a call for evidence about this European Innovation Act. Sustainability is not even mentioned if you go and look at the call for proposal. But there is intellectual property. And intellectual property is at the core of the European Innovation Act. How? Saying that it is fundamental for access to finance, and also an important instrument for public R&D exploitation of the innovation coming out of the university. So I can say that to a certain extent, sustainability and IP in the legislation are watertight, okay? Sustainability on one side, and when you talk about IP, sustainability is not there, okay, in the mind of the legislation. This is at least a first impression. Let's move on, and I try to go more into the detail with two case studies that by chance are the things that I'm studying. That are right to repair under the Directive 1799 and geographic indication. Okay, so let's see how in this situation intellectual property and sustainability are communicating, are coordinated, are matching together, okay? For those who are not familiar with the Right to Repair Directive, the so-called common rules on promoting the repair of goods, well, the idea is that right to repair is a building block of circular economy, and of course, it is something that matters in this idea, or in this paradigm shift towards sustainability. In the directive, the right to repair is directly connected to the sustainable goals of the eco-design requirements. So the eco-design regulation and the directive are really overlapping to a certain extent, in the sense that the right to repair applies only to the categories of product that has certain eco-design requirements. In the directive, the right to repair is supported by means of informative measures, promotional measures, but in particular there is this obligation to repair on manufacturers. I want to stress that the directive on right to repair is an absolute harmonization intervention, so every member state is compelled by this kind of harmonization. And right to repair, very interestingly, is shaped by the EU legislator as of mandatory nature, and so also it goes beyond contractual derogation. So, sounds promising. In particular, this obligation to repair on manufacturers, Article 5, it is structured as an obligation on manufacturer that goes beyond the contract, in the sense that the consumer or the user has the right to ask for repair, not on the basis of the contract, but on the basis of having the product in its possession, okay? Right to repair should be performed by manufacturers as an obligation, okay? Only for those kind of products that has the eco-design requirements that I was mentioning before, except for technical impossibility, so that's quite a strong obligation. plus the directive says that the repair should be provided by manufacturers at a reasonable price and a reasonable time. Even this thing I think is very right and fair criteria to build up this right to repair. More precisely, right to repair cannot be refused because of previous independent repair, and that's nice because it establishes this idea of right to repair as a right that can be incentivized and promoted beyond the contractual tying situation with the manufacturers. Right to repair should not be impaired by the use of independent spare parts, and that's something really, really interesting, also considering, again, the Audi case about trademarks and this vibe not really supporting repair in general. So it seems that this paradigm shift, we can find it even in this directive. And as I was mentioning before, Article 5 expressly states that this obligation to repair, or as you want to see it, right to repair prevails over contractual clauses, hardware or software techniques. So it sounds really, really nice, but of course then it comes IP, in the sense that right to repair, of course, goes, as I was saying, against contractual clauses, hardware or software techniques, but then there is the addition, unless justified by legitimate and objective factors, including intellectual property rights. So it is, to a certain extent, an absolute contradiction of what we are just saying, because as you all may know, the right to repair clashes with intellectual property rights. It's quite, already it's quite a classic theme, okay, how intellectual property is an obstacle to repair. As I was saying before, the directive mentions provides this rule that right to repair includes and admits the use of independent spare parts, but then the directive adds that are in compliance with intellectual property rights. And finally, all Article 5, paragraph 6 says that the provision about this obligation to repair in its entirety should be without prejudice to the protection of intellectual property rights. So once again, IP that puts really a strong push against right to repair, and so to a certain extent against sustainability. Why is it so? Well, this is also an aspect that we should look at, in the sense that the original proposal did not cover IP at all. And that's when I started to study this topic, and I had the proposal, I looked at the proposal about the directive on right to repair, and I started thinking, wow, IP is not mentioned, so there are a lot of challenges. It's something that I think could be interest to study, to coordinate the right to repair in the silence of the law. And then during my research, it came out the final text, which was even worse, because as I was mentioning to you, IP was directly there to stop, to a certain extent, the right to repair. So when you look at the legislative history, and even talking with colleagues that are more inside, let's say, certain dynamics of EU lawmaking, you learn that this agreed text intervened with this carve-out in favor of IP for a mix of defensive legislation. I add policy and greenwashing to a certain extent. But the idea is that the competent DG was the one more related to consumer law. Okay? Then to a certain point in the lawmaking process, the issue comes up, well, and what can we do about IP rights? Because we cannot go so strongly against IP rights. Okay, let's put a carve-out provision. So it was not even something that was originally thought as a problem, and when the problem came up, they decided to take a defensive position, saying, okay, we cannot go against, but without really a systemic view or a deep reflection about the impact of the legislation, the result, and the problem of intellectual property. So I think that it is quite instructive also about certain dynamics in the EU lawmaking process. Then, okay, we can assume and let's say we have to take into account that sustainability is not internalized in IP law, at least for the right to repair. It's something that we have to see. And so, as the Audi case demonstrates, the repair clause is not a horizontal defense that it is available. So you have it in design law, but nothing more. At least for me, the solution is to propose, and that's what I argued in the chapter mentioned kindly about the project by Francisco, that to a certain extent, right to repair should be with prejudice to IP, so we have to interpret this in some way in order to make effective this directive without just having a rule about an obligation that cannot really be applied. So this is, for example, an idea of an evolutive interpretation in order to push for sustainability in the context of IP law. Then I'm moving to geographic indication, because also geographic indication is a very dynamic field of law. There has been a recent reform about both the agri-food sector and the craft and industrial sector. As you know, GIs are a sui generis intellectual property right. They are strongly protected, so they have a strong protection in terms of IP. But GIs are also a wider regulation of the traditional production. So are both IP and as this wider approach being also a collective governance of local producer and territorial district and this kind of production. It is important also to stress that GIs are of exhaustive EU competence, so it is quite nice to look at it in order to, again, check dynamics about the lawmaking process at the EU level. Sustainability is there definitely after the last reform. Especially in the agri-food sector, we have sustainability promotion, which is directly regulated by GIs. Within GIs is internalized. We have sustainability parameters that by the regulation expressly should be above the normative standards. So we have this kind of definition, also definition that includes environmental sustainability, so let's say social sustainability, but the focus is definitely on the environmental side, even if it is mentioned both the social dimension and economic dimension of sustainability. Sustainability initiatives can be agreed among GIs producers. That's the approach of the GIs reform. And in addition, there can be also sustainability commitments that are mandatory for GIs producers and can be imposed by the GIs consortium. And in particular, they can be inserted in the so-called product specification. So they become mandatory. Plus, there is also the sustainability report, which is something that every GIs to a certain extent can produce, can prepare, and then the report is published by the European Commission. And there are also some rules about how the report should be drafted, and that should also be, let's say, it should include aspects and terms that can be understandable by the audience. So it's really a nice approach to sustainability and the divulgation, let's say, the communication of this sustainability effort towards the public. And so it is nice to see that within GIs, sustainability has built up with this bottom-up approach. It is not saying you have to do this and that by the legislator, but the legislator creates the legal framework for geographic indication to try to push from the practice the sustainability commitments that they consider better according to the different peculiarities of each product and each territory. Then we move to the other regulation of the reform, the one that introduced in parallel craft and industrial product. And quite surprisingly, they are not definitely aligned in a lot of aspects, and that's quite critical as an aspect in general. And also about sustainability, we have some differences. For example, okay, sustainability is there and it is promoted by the GI law. But sustainability is not defined as we have it in the agri-food sector, and also is not defined in its environmental and social dimension. The only reference to sustainability is more related to economic sustainability. So this idea that we have to promote, defend, protect the sustainability of local production, traditional production that otherwise risk to disappear in the global market. Okay, so it's more like an economic sustainability, more related to protection, protective goals as such. Even in this field, there is this idea of sustainability initiatives, sustainability commitments that could be made mandatory by the GI's consortium. Sustainability report is not provided, so we have not this instrument that I think it could be valuable. We have just some reference to internal collective analysis by the GI's producer in order to see how it can be improved, the level of production, but it is, again, more an economic internal aspects than a public, okay, a public approach. So again, we have a bottom-up approach, but it is a little bit less stringent and less focused, especially on environmental sustainability. So, at least in my opinion, to the real meaning of sustainability. Okay. Why geographic indications show this greater, let's say, this push for sustainability in comparison with other intellectual property rights? I think the reason is quite evident, the fact that GIs have their roots in a deeper policy mix and especially in agricultural policy. So GIs with this root in agricultural policy go beyond a classic IP logic. Okay, and I think it's quite interesting to see that's this different. And to a certain extent, it is true that GIs are very protective, also because of this agricultural policy approach, but they are also very committed to sustainability. So we have a kind of a paradox, because to a certain extent, talking about the IP protection, they are less balanced because the agricultural policy objective is quite strong in order to require protection, but they are more proactive for sustainability because they have in mind this idea also of the agricultural policies that should, of course, integrate sustainability objectives. I want to stress another aspect of this case study about GIs. Craft GIs are not as much as sustainable as agri-GIs because, I think for the same reason, because we don't have the background of the agricultural policy. And so we are going again on a more classic economic field. We are talking about a more classic IP logic. And then, of course, again, the risk is that we go in the same loop in just looking at the economic aspects without taking care of environmental aspects and social aspects of sustainability. In my opinion, but it's not just related to sustainability, but in general about this reform, craft GI should follow agri-GIs and the agricultural GIs as an archetype. Otherwise, I think we lose the rationale and the peculiar kind of protection of GIs. But for this discourse that we are sharing together about IP and sustainability, I think it is quite interesting to see that this fact that craft GIs are not as committed as agri-GIs towards sustainability is related, at least in my opinion, because of this more classic economic approach, and so to a certain extent too much of an IP logic. Okay, when IP goes there, sustainability comes out to a certain extent. Of course, GIs are far from being perfect. There are a lot of also of criticism within the GI literature about sustainability within GIs. First kind of objection is just the classic dynamic of garbage in and garbage out, in the sense that they say that they are sustainable, but Are they sustainable? It depends on what they commit. And so if there is no control from above, then we can have the risk of a sort of greenwashing, because they say that they are sustainable, but actually they are not so much. And so there are someone that it is criticizing this reform, saying it is to lose, in the sense that we have no hard obligation, no top-down obligation, and so sustainability should be stronger even in the field of GIs. But at least for me, okay, intellectual property in general is less perfect than GIs, because we don't have any kind of approach or push about sustainability. I want just to mention something that I'm studying for different aspects. Trademarks and the control by the EU IPO when you are registering a trademarks, okay? I think that every one of us is familiar with the organic certification, so the biological product for Italian speakers. Otherwise, I think that organic, okay, the green leaf. If you go and register an organic, a sign that contains the word of organic or bio or eco for Deutsch speakers, even if the regulation about organic products says that you cannot use this kind of signs within the commercial, let's say, presentation of the product unless you are certified, EU IPO says, okay, but as a matter of principle, I have to start with approach of bona fide presumption, and so for me, it can be registered as such, okay? And then maybe afterwards we will go and check. I think it's this idea that not really taking care about sustainability we can find really in a lot of aspects of IP rights. Okay. And in general, IP is too reluctant about sustainability. And of course, GIs are too optimistic, and so just relying on bottom-up approach. But then you look back at the right to repair directive, and then, okay, what's the result of the IP policy? Just to say, please stop, because we cannot have a prejudice to IP in general. Again, this is not to say that GIs are better, but it's just to look at how these different aspects are interacting. So it is true that GIs are very peculiar. It is true that GIs are a sui generis regime in a lot of senses, but at the same time, they show that the classic IP logic is very, very, very impermeable to a certain extent with respect to sustainability. So going back to the three formats that I was talking about, okay, I think that the legislation shows, especially in IP law, to be very reluctant to have this kind of impermeability towards sustainability, and that's a problem. That's a problem also because if the law is that one, also in terms of case law, everything becomes more difficult. I don't want to say that, okay, the European Court of Justice could not have done better in certain cases, but it is a matter of fact that the law is that one, and you have to deal with the law that you have in order to prepare the judgment and to find a solution. And that's why also the doctrine is struggling to propose correct interpretation, which is not really very an easy task, and that's why also the doctrine is very critical about the legislation, the case law, and all the situations. So, in order to conclude, which is the bottom line, what's the bottom line of this reasoning? Okay, academics are never happy with the law. I think that everybody agrees on this fact. But at the same time, I think that that's our task, because in this way we can play a role and try to propose evolutive interpretation that can contribute both to an enhancement, let's say, of both legislation and case law. Of course, academics are not always great and immaculate. There are a lot of also certain old-fashioned approaches that to me at least sounds like turbo-capitalism about IP and sustainability and environmental aspects, but at least as maybe younger scholars, we have really to take this idea of the paradigm shift towards sustainability seriously. And as I was saying, that's how our contribution can really help the system in this mission, or in at least trying to do it. Thank you very much for your attention.